All right, we should be audible now to folks out in Zoom land. Ms. Nelson, are you able to hear us?
Yes.
Great, and Ms. Rivers?
Yes, good morning. Happy New Year. I can hear now.
Good to see you, good to hear you. All right, sorry for the few-minute delay. We were just reconnecting with technology after a couple weeks off. We have the calendar says motions hearing. It's a bunch of plea and arraignments. There is a bond hearing I think we'll do. There was a plea we were going to take. We cannot do that because one of the attorneys is now unavailable. I'm here in person. I see Ms. Charles is here. Happy New Year. Welcome back. We have Sean Patel here from the Public Defender's Office and a bunch of folks who are connected remotely. For the next few weeks, remote appearances are A-OK. You will govern yourself accordingly. You're welcome to be here. I'll be in court for every calendar we have, but I don't require others to be in court unless you want to be. For example, the plea we were going to take in Mr. Slayton's case, Mr. King, the defense attorney, wants that to be in person. He wants to be with his client. His client's young. He wants his dad to be in the courtroom. Mr. King's, Mr. Slayton's. I get that, and we will accommodate that, but it is also fine to be remote. So you can take care of what you need to, and if you're on the defense side, your client is okay that you're not where he or she is. We're going to try that for a few weeks. I don't know how broadly word got out, but we are postponing jury trials for a couple of weeks. And towards the end of next week, Chief Judge Brasher is going to look at the numbers again and we'll see what we do. We'll still call our trial calendar. We'll still have our pre-meeting. That can be virtual for anyone who doesn't want to be here. But again, I'll be sitting right here. Sure. We'll have the conversations we need to have. We'll call the calendar, but I don't expect folks to be here who aren't comfortable being here. That's okay. And then we'll take a measured approach as to when we might have trials. Some of it's out of my hands. If the Chief Judge says no jurors are coming in, then we may miss a couple of those trial dates that are part of that trial calendar that we'll call, I think it's on the 10th that we're having the call of the calendar. But some of us will be meeting in advance to try to schedule some of that. So those are the updates. If you have questions about procedure or concerns or updates about your own situation, as always, Ms. Nelson is your point of contact. She was working through a bunch of emails this morning that were in her inbox with updates from folks. So what I'd like to do is just get through the calendar, figure out who all is here, and then we can take it in whatever order makes the most sense for the lawyers and the clients. Position 1 is Dexter Beard. And I know, Ms. Patel, you've assumed that case now.
Yes, Your Honor.
But neither you nor Mr. Franklin tried. I think the trial was pre-Patel, pre-Franklin.
Correct.
With the, I guess back then it was the Downs division.
Correct.
Okay, and Mr. Abate, is this your case now?
Yes, Judge, and I'm gonna walk over because I didn't realize that in person was an option. I hate Zoom, so I'm gonna walk over.
Great. Is Mr. Beard here? Great. So and that's still a Mr. Abate, make your way on over. We won't do anything until you're here.
Thank you. Thank you, Judge.
Ms. Patel, your role today is a bond hearing.
Yes, Your Honor.
We'll do that. Position 2 is being continued. Mr. Slayton, if he's here, I can give him an update. We'll just bring him to the door. I can let him know what's going on. But his lawyer can't be here, but wants it to be an in-person plea. So we'll do that in a second. I'll give him that update and you all can take him downstairs. Mr. McLean, he should be here. That's a plea and arraignment. Ms. Patel, your case, or is that Ms. Wood's case?
That will be Miss Wood.
It's mine, Judge. Good morning.
Hey, good morning. How are you?
Good, thank you. I would like to speak with 88 Charles about this case. So if we could come back to this, I have some information. We might be able to work this out today.
Fantastic. Well, ADA Charles is here. I'm sure she'd like to talk to you. So we'll do that. We have Mr. McLean, so we can sort out whatever communication stream we need. Position 4 is Harvey Johnson, also should be up. He's here, he's in custody. Who is representing Mr. Johnson?
Your Honor, that will be my case. I've spoken to Ms. Charles. We are going to try to loop back after the call of the calendar in terms of resolving it.
Great, okay. Derek Avery should be here. He is. Mr. Avery, good morning. You were with us 2 months ago, almost to the day, and you were gonna find yourself an attorney. I think I checked yesterday and no one had filed an entry of appearance. Have you found an attorney?
Your Honor, if I could clarify,
Yes.
when Mr. Avery was on the calendar, we were not sure if our office could represent him because there's a cross defendant. The allegation is that Mr. Avery shot at the individuals that armed robbed his son. And so I did find out we conflicted off of that defendant's case early enough that I can represent Mr. Avery. I'm not sure if Your Honor wants that other case in our courtroom or this case to follow the other case, but Mike,
What's the other case number?
it's 21 SC 179257. It's in Judge Dunaway's courtroom. Mike Webb has the represents Mr. Williams. It seems like it's a little bit further along than our case.
Okay, well, we took a little break, I guess, to sort out the representation situation. I'm following up that case now. But what you're explaining, thank you for that refresher, and Mr. Avery, don't panic. If you're supposed to have counsel appointed, you get a lawyer. You're not gonna have to suddenly win the lottery to afford one. You get a great attorney either way. But that's an interesting question about whether cases ought to move together. Okay, so Carlos Williams is represented by Mr. Webb, coincidentally, because he's also in Dunaway. But
Correct.
Mr. Williams wouldn't have to get a new attorney if we took over the Williams case. And what you're saying, Ms. Patel, if I were to read the indictment, the alleged victim of the armed robbery, or one of the victims in there, is someone related to Mr. Avery, and Carlos Williams is an alleged victim in Mr. Avery's case.
Correct.
Yeah, it seems like the same. I'll talk with Ms. Nelson, but I think it makes sense for us to pull the Carlos Williams case over here. Okay, have you spoken with Mr. Avery, or we should make sure that happens this morning?
I've spoken to him. I told him I would speak to him further about the case after the call of the
Great,
calendar.
why don't you do that, and then if the two of you agree that Mr. Avery's gonna waive arraignment, you're free to excuse him. I don't need to. He's free to go after you two have spoken. If it's a waiver, if he doesn't want to waive it, we need to make the record of his arraignment. Great, you can fill out the appropriate paperwork.
Thank you, Judge.
So, Mr. Avery, Ms. Patel, from the Public Defender's Office is gonna represent you. You two are gonna talk a little more before you should go. If she says you can go, that's fine, but she's gotta discuss a few things with you. And then this other piece we're talking about, there is a case against someone you allegedly shot at. He is the defendant, it's with another judge, but according to Ms. Patel, the cases are kind of intertwined. So I will probably take that other case because your case has a lower number, just randomly it has a lower number, and the higher number cases go to the lower number cases. We're not gonna link the cases, they're separate, different lawyers, you got nothing to do with that one. The connection is simply the defendant in that other case is the alleged victim in your case. So those are all gonna be here, or so you understand what we're talking about. But after you and Ms. Patel have spoken, if she says you're free to go for it. Any questions? Yes, sir. All right. And Andre Rudder. who would be handling Mr. Ruddock's case if he was?
Judge, I just saw on Odyssey that Mr. Webb has entered an appearance on that case. So I believe that will be a conflict case.
Okay, any idea why that would have happened?
So I'm actually confused as to why it is. There were notes from the first appearance judge that said it would be a conflict case. Ms. Patel and I tried to determine ahead of time what the conflict was because I believe the complaining witness's case had been closed out with our office. So I'm not sure. I need to look into that some more, but it looks like Mr. Webb filed an entry on the 27th.
Yes, he did. Okay, and he is not available right now. I don't know that Ms. Nelson, did Mr. Webb have any contact with you about excusing Mr. Ruddock?
Not that I recall, Judge. I'd have to go back through my emails to see if he did reach out to me.
Okay, well, we'll hold off on a bench warrant for Mr. Ruddock because of the change in lawyers, and we'll see about that. Okay. Position 7, Marquise Daniel. He waived arraignment. Richard Grossman represents him. Mr. Grossman filed a waiver of arraignment. I don't know, is Mr. Daniel here? Doesn't need to be. Mr. Abate, I don't know if you've had any contact with Mr. Grossman, but that's to whom you should be sending discovery. Yes, Judge. Ms.
So
Nelson?
both parties were excused to appear today after the
Okay.
filing of the waiver.
Great, that's what I thought. So he's filed a waiver. We'll get a scheduling order out, and if you could please get discovery to Richard Grossman. Yes, Your Honor. And finally, we have Cedric Johnson.
Judge, that'll be my client. I actually waived his arraignment and his appearance as well. I didn't think I would be here today. But I do have good contact with him. And so I do anticipate speaking with Ms. Charles after the day to see if we can come up with a resolution for that case.
Okay, so you and Mr. Johnson are in regular communication. This was a non-complex transfer because Mr. Johnson is a repeat offender, but his priors are older. Okay, so we'll get a scheduling order out, and just wait if you, Ms. Charles, sort it out, let us know, and we'll get Mr. Johnson back here sooner.
Thank you, Judge.
All right, so if we could get Mr. Slayton to the door, I'll let him know what's going on, and then we will pause a bit so that you can speak with a few folks, and then we can do Mr. Beard's bond hearing, unless you need the bond hearing to go further.
I do not.
Okay.
Are we gonna call the plea and arraignment calendar?
I thought I called, there's another calendar.
There is.
What? Okay. I printed the only calendars that are attached to the meeting notice.
Right.
So Ms. Nelson will have to send.
Okay.
I'll send it to you right. I'll send it to you right now, Judge.
Okay, it's not in our, hey, Mr. Slayton, how are you?
Good.
You remember me?
Yes, sir.
Good. I'm still Judge McBurney. You're still Mr. Slayton. Happy New Year.
Happy New Year.
I want to give you an update. Mr. King, your lawyer, he is having to take a break from court for a few days, just quarantining, being safe, all that kind of stuff. So we are not going to do your plea today. He wants to be here in person with you,
Yes, sir.
and wants your dad to be here as well. But because Mr. King couldn't be here, we told your dad, time out, we'll reschedule this. He doesn't want to have it be a Zoom plea or anything like that. He wants to be there with you.
Yes, sir.
So we're gonna try to do this early next week when Mr. King can be back in court.
Yes, sir.
Just want to tell you that so you were ready, why did I come over here? Mr. King told me we'll take care of business. That's still what he thinks is gonna happen. Of course, it's ultimately your decision. You're the last defendant left in that case.
Yes, sir.
But we want to make sure you and Mr. King can be sitting next to each other at the table for a conversation we all need to have,
Yes,
okay?
sir.
So I should see you in about a week, all right?
Yes, sir.
Be safe. Good night. So yes, we'll call this other calendar as we get my hands on it.
I'm gonna try to get the prosecutor to dismiss her case. Yeah, he isn't.
All right, I've got the calendar for now, right now, and my understanding is that we do need an interpreter for position 6. And we have one of our favorite interpreters here in court for 2022. That's Mr. Sargosa Garcia. I don't recognize the defense attorney yet, or maybe there's someone online. So we'll figure it out. Okay. Let me get my hands on the calendar. All right, a few more names. We've got Tiffany Singer.
Your Honor, Ms. Singer was the individual in Haralson County. She made bond. She was in Haralson County. Miss Nelson did a CPO. She just was not produced.
Okay, so Ms. Singer has this big bond in her Fulton case.
Correct.
She's got business in Haralson. We tried to get her from there. You're hot. Is that? Okay, you know, did you need me? Go out there with me. Okay, so she's in Haralson County. We just weren't able to get her here.
Correct.
Okay, do we know why she's in Haralson County?
There was a probation violation arrest, and then when she was arrested on that violation, she was charged with crossing the guard lines.
All right, so Ms. Nelson, what's the best next step for Ms. Singer?
I have to find out why they did not produce her, and if she's still in custody, maybe we can do a Zoom hearing to have her arraigned, if that's the next step for her.
Okay, Ms. Patel, have you been able to speak with Ms. Singer, or it's not easy to talk to folks who, I don't know how close Haralson County is?
I have no idea where Haralson County is. I have not been able to speak to her, and I'm not sure our office would potentially represent her given the bond she was able to post. But I am, if there's a way to do a video visit, I'm more than happy to talk to her in advance.
Okay. Haralson County has a beautiful courthouse, according to, and it is out I-20 and then north a little bit. Not a million miles away, but we have to be able to get her back here, and then we need to work through representation. Okay. Rashay Baldwin ought to be here. Is that someone who's up? Yes, okay.
Your Honor, last night after I visited Miss Baldwin, I found out that our office had conflicted off her case. There's some urgency in resolving this. She's a double amputee. The 2 charges are misdemeanors. Yes.
Why is it here?
Initially, she was charged with felonies. They did not present the felony to grand jury because it was a criminal damage.
The DA's office kept the case.
Yes,
Okay.
and I understand as of today that Mr. Webb isn't able to be present. I'm trying to see what the state can do without me having to do anything at all.
Well, we have a couple options. What's the nature of the conflict?
She is the victim in 2 different CWAC cases.
Okay, all right, so that's an issue.
Mhm.
What I'll do, Ms. Nelson and I can reach out to a supervisor with the conflict defender's office to say, so we'll try to keep our powder dry and only say urgent when it's urgent, but this would be one where someone could get out of jail likely, if the conflict defender's office could plug into this one. Okay. Right. You spoke with Ms. Baldwin. Would it be helpful if I let her know what's going on, or you let her know? I don't know how you left things with her.
She thought I was her attorney, so it might be helpful for her to know, and just so that she doesn't get upset that we're trying to work it out
Yep.
today.
Okay. But what would be ideal is if we could get someone from the conflict defender's office here today. Ms. Nelson, do you mind reaching out? I have no idea who we reach out to, but just we do have those 2 supervisor names to see if we could get a conflict defender to come by this morning or
Okay, I will.
or dial in.
I will. Yes, I will reach out to see who I can find.
Thank you. All right, let's move on. Position 3, Rhonda Walker.
Here.
Hello, Ms. Walker.
Good morning.
Judge, she'll be
Yes.
my case. I will get Miss Patel to give her my number so she can step out in the hallway and we can have a little chat. And then I'll have an announcement for the court after that.
Great. So Ms. Walker, you're going to be represented by Ms. Wood, who is remote today. But she'd like to talk to you on the phone. You'll get her phone number in just a few minutes. Please talk with her and then come back in and we'll hear from Ms. Wood, with you and me in the same room, what the next step is in your case, okay? So Ms. Patel is going to give you a phone number in a minute. Once you got that, then you can call Ms. Wood and then we'll take it from there.
Thank you.
You bet. Position 4 is Charles Carlisle.
Your Honor, Mr. Carlisle is in custody and he will be my client. I'm going to waive arraignment today and plead Mr. Carlisle not guilty.
All right, Mr. Abate, your case? Yes, Your Honor. Do we need to talk to Mr. Carlisle at all, or can he go back downstairs?
I believe he would just like to come out to hear my announcement to the court.
All right, we'll do that in just a second. 2 more positions. We've got a co-defendant, Mr. O'Neill. But is Mr. O'Neill just a warrant for him? He's not in custody?
I think there should be a grand jury warrant. I don't think he was initially arrested.
Okay, so he's on the calendar, just co-defendant, but we don't believe we know where Mr. O'Neill is. Correct, okay. Okay, so we'll get Mr. Carlisle out here in a minute, and finally, David Sargosa Garcia.
Judge, he will be mine. And Ms. Patel has graciously agreed to speak with him alongside the interpreter on my behalf. So we'll have an announcement after the call of the calendar.
Fantastic. All right, any other calendars for this morning? No, okay. Is there anyone who's here who thought I was gonna call their case today? You've got other folks here, you may be here for cases I already talked about. No hands. Okay, then why don't we do this, because our interpreter is here, well, let's bring Mr. Carlisle out, please, and then we'll bring, Mr. Sargosa out. Do you mind, Ms. Patel, talking to Mr. Sargosa right here rather than in lockup? Or would you rather talk to him in lockup?
Based on some concerns Ms. Wood relayed to me, I'd like to speak to him in the back.
Let's take care of Mr. Carlisle, because then he can go. And then we'll take that break where people talk with their clients briefly, figure out who can get out of here. And we skip around. Carlisle, stick seat right there. Good morning.
Morning.
I'm Judge McBurney. Your case, which you have with a co-defendant named Mr. O'Neill, has been assigned to me. Today is your arraignment day, which we can handle in one of two ways. One way would be you do not waive arraignment, I read your whole indictment, all that kind of stuff. The other is that you waive arraignment, which means you're pleading not guilty at this time, but you don't need me to read into the record everything you're charged with. Ms. Patel, your lawyer, has told me that she thinks you want to waive arraignment. I'll read the whole indictment out. But I wanted to bring you out here once a week with me, because we'll be working together on your case as it moves along. But two, just to make clear in front of everyone what's going on with your case. Your co-defendant, Mr. O'Neill, is a fugitive right now, not in custody. You're the one in custody. After today, I'll enter a scheduling order that's going to direct the prosecutor, that's Mr. Abate sitting over there in a gray suit. He's going to need to get all the discovery he has, whether they're police reports or video or whatever the state has. He's going to get that to Ms. Patel, so she can look at it and see what the case looks like. Then she will get with you to talk about that. Say, hey, this case looks pretty good for us. Doesn't look so good. Whatever her professional opinion is, you guys will talk about it, and then you guys will take it from there. There are going to be motions that she files. Maybe there's something to suppress. Who knows what? But that's where her expertise comes in after she talks with you about the case. Ultimately, we need to resolve this case, either because we have a trial or because Ms. Patel and Mr. Abate work out some plea. And I'm here either to take that plea or preside over the trial. But I know you've been in custody for a while, so I'm anxious to get us to that date where we either have a trial or we take the plea. But certainly Ms. Patel needs to understand what all the evidence is or isn't in your case to help you figure out what's next. Does that make sense?
Mhm.
Ms. Patel, anything else you want to cover at this time?
No, Your Honor.
All right, Ms. Patel will be connecting with you. It may be that it's video call, maybe she comes to the jail. You've got her info, so you know how to reach her. I will see you next, either because Ms. Patel has filed some motions on your behalf after she got the discovery, or because we're taking a plea in your case, because you agreed to do that, or that last option, it's time for trial. Then we'll get you in here and pick a jury, okay?
Okay.
All right, Mr. Abate, any issues up front that you know of with discovery? Something that's a little fine. Not that I'm aware of. All right. Sounds good? Thank you. Then, as far as if you wouldn't mind going with Ms. Patel in the lockup to have a brief conversation with Mr. Sarkozy Garcia, I will take Ms. Patel's lead as to whether we need to bring them out here. It may be that the conversation the three of you have is all that needs to happen. But once Mr. Patel says he's good to go, we'll be good to go.
Thank you, Judge.
Thank you. Mr. Charles, would it be accurate to share with the conflict defender's office that you believe you're in a position to work out Ms. Baldwin's case? I don't want to put you, if the answer is you think Ms. Baldwin needs to serve 24 months for a trial, it may be something that wasn't going to work out today. So I don't know if you, Ms. Patel, even talked about it.
What she asked me, I would need to go get some authorization. I couldn't do immediately to the tax people. And so I would like to discuss it further with my senior before I agree, but I would be able to resolve it today through authorization.
You think you'd be able to connect with someone today?
Absolutely.
Okay,
Doing
great.
a very correct step.
All right.
Doing that.
Morning. Ms. Wood, you wanna text me your cell phone number because you could be chatting with Ms. Walker right now. Ms. Patel seems to be stuck.
Yes, Judge, I'll put it in the chat.
Thank you.
Thank you.
If you don't mind giving this to Ms. Walker, who's the lady seated in the olive hoodie there. And Ms. Walker, if you call Ms. Wood on this number and go step on outside, you guys can have the conversation you need.
Thank you.
Thank you.
It's fine. Yeah, I think he will be the next one. It's Ellie now.
They're having a conversation with the interpreter. When they're done, we'll know if that gentleman needs to come out or if we're done and the interpreter can go. I just wanted to get the interpreter in and out. So once they're done, we've got other stuff we're ready.
All right.
Thank you, Chair.
No problem.
Would you mind, Deputy? I'm sorry, would you mind getting, I need to find out from Ms. Patel how much longer she. Thank you.
Yes, but right now, we will not be right now, whether or not it's brought out.
Mr. Patel, we can keep Mr. Sargosa up here more if we need to, but otherwise I want to get us to some of these other things.
No, Your Honor, I've spoken to him. I don't know if Your Honor wants him to be brought out, but we are just going to arraign him not guilty today. And I need to speak to Ms. Charles about a potential future court date for either a bond or a plea.
Okay. Is he waiving arraignment or?
Waiving arraignment,
Waiving
yes.
arraignment. Okay, I don't need to check with him, unless you think that will somehow stabilize the situation, but you all had a good conversation.
Well.
I think it's fine,
Okay,
Your Honor.
then Mr. Sargosa, if you can go down, we were bringing people downstairs, we're done with that. Why don't we give you a chance? I know there are a few folks you want to connect with, maybe able to leave after that, and then we can do Mr. Beard's bond here.
Thank you, Judge.
Great. Thank you, Mr. Laris.
Yeah.
Can you sign anything, or are you good?
Well, I think I didn't display that. Important data.
You can always come back. Fine.
Yeah. That's the last.
Thank you.
Mr. Avery, you can feel us. And then later she follow outside as well.
Judge McBurney.
Yes, ma'am.
Sorry, I couldn't see you on here. I have an announcement on Miss Walker.
Okay.
Don't know, did she come back into the courtroom?
She is not back in the courtroom, but we'll, I think maybe someone's gonna get her.
And Judge
Okay.
McBurney, that'll be my case as well, 88.
Hi, Ms. Beza, how are you?
I'm okay, thank you. How are you?
Hanging in there. Here comes, Ms. Walker, the gentleman went out to get her. She's coming. Okay, so Ms. Walker is here, she can hear what you need to say, Ms. Wood.
Thank you, Judge. We are gonna waive formal arraignment today and enter a plea of not guilty. I did get updated contact information for her, and I confirmed that her address in Odyssey is correct. So I will have Ms. Patel fill out the waiver today, and we would just ask for another court date.
Okay, so Ms. Walker, I'll be entering a scheduling order that's gonna tell Ms. Beza, who is on this call as well. You can see her on the screen, she's not here in court. She's gonna get discovery in your case, so your lawyer, Ms. Wood. So Ms. Wood knows a little bit more about what these charges are all about, what this charge is all about. And then, you and Ms. Wood can talk about it, figure out what you're gonna do next with the case. I will see you next, either because there's some motion we need to work through, or because your case is resolving somehow, okay?
Thank
So
you.
you stay in touch with Ms. Wood. If you have to move for some reason, you need to let her know your new address, because we mail things to that address that's in the system. And if it doesn't get changed, that's on you. And I want you to be able to stay out on bond, okay?
Thank you.
All right, Ms. Wood, anything else?
No, Judge.
Ms. Beza, anything else in Ms. Walker's case?
No, Your Honor.
All right, thank you.
Thank you. May I be excused?
Yes, you may. And Ms. Wood, Ms. Walker, you are free to go too.
Do I need to sign the waiver?
No, Ms. Patel is gonna fill that out. I think she's outside with Mr. Avery right now.
Sign the waiver.
Ms. Wood, there's no client signature on the waiver form, is there?
No, Judge.
No,
Okay.
you're good to go.
Thank you.
But Ms. Bernard, thank you for joining us.
You're welcome, Judge.
So you need to tell me logistically how we might work this out. Ms. Baldwin is here. Ms. Baldwin is up. Ms. Baldwin is here. She's in custody. And it sounds like you did a little background research to confirm that there is a conflict. It sounds like it is a serious, in the sense of meaningful conflict. Ms. Baldwin is a victim in a couple cases where the public defender's office represents the accused. So Ms. Baldwin, I think, was appropriately transferred to your team, but Mr. Webb did file an entry just before he took his leave. I don't know that he dove into the file at all to see, wait a minute, these are two misdemeanors. Ms. Charles, who is the prosecutor handling the matter in my courtroom, has said that it may be workoutable. She needs to talk with a supervisor, but it sounds like maybe you two should talk, and then obviously you would need to talk with Ms. Baldwin. I'll need to figure out logistically how we do that. Is Ms. Baldwin in a wheelchair? How does she? She's in a wheelchair. Okay. We could figure out a way to get her out here. Maybe we do this towards the end of the session, clear the courtroom, so that you, Ms. Bernard, could have a private conversation with Ms. Baldwin. Do you want to talk with Ms. Charles, the prosecutor, first, or what will be most productive for you?
Yes, Judge, I need to know what the offer is. So if I'm gonna put my email in the chat. If she can, and my phone number. And she can email me the offer, and if she would give me a call, we could talk a little bit.
Excellent.
And then at the end of the calendar, whenever it's convenient, if I could speak to Ms. Baldwin by telephone, my phone number will be in the chat, then,
Okay.
and relay whatever offer there is, and maybe we can get that case moved today.
Fantastic. I very much appreciate you parachuting in on that.
You're welcome. Let me get that information in the chat.
Okay. All right, so go back to our first calendar. We can do Mr. Beard's bond hearing. Ms. Patel, you had a chance to talk with the folks. You talked to Mr. Avery, he's on his way.
Yes, I have waived arraignment for him.
Okay, and you are, by the way, gonna fill out the waiver for Ms. Walker.
Yes.
His position is 3 on the clean arraignment. She's been released as well. All right, so why don't we do, if you are ready for it, Ms. Patel, you've been walking around to do Mr. Beard's bond hearing.
Could I have 2 minutes? I just need to go in the back and then I just need to speak to the family to get their names is all.
Okay, these are folks here on behalf of Mr. Beard.
Correct.
Okay. Mr. Charles, have you seen, you now have Ms. Bernard's contact?
I'm just looking at today.
Fantastic. If you all could connect while Mr. Abate is handling this file here.
And Your Honor, I'm ready to proceed.
Okay, if we could bring Mr. Beard out when you're ready.
Yes,
Please.
for the deputy pays. I'm ready for that A2. Beard.
Your Honor, I would ask that my client be able to sit because he does have an ailment that.
No, that's fine, it's a bond hearing.
Okay.
You can vote for me.
Perfect.
If you want to go to the podium, you can, but people remaining where they are, just using the microphones, it's fine.
Okay, thank you, Your Honor.
Sure.
You're awesome.
All right, Ms. Rivers, can you hear me?
Yes, Judge, I'm ready.
Great. Well, let us get started. This is position 1 on our motions hearing calendar. It is 14 SC 130911, State versus Dexter Beard. Mr. Beard, I'm Judge McBurney. Your case is now assigned to me because I have inherited all the cases that Judge Downs presided over. She presided over your trial, where you were found guilty of murder. And then she entered in an order saying, no, I don't think that the jury got it right. That was appealed, and the Supreme Court upheld Judge Downs's, we call it 13th juror ruling. She decided 12 other people got it wrong, and she knew better. And she decided that you ought to have a new trial. So you remain charged with murder and anything else for which there was not a not guilty verdict. I don't have the verdict form in front of me right now. But we're here to talk today about bond. Ms. Patel, who is your lawyer now, Mr. Fair represented you at trial, and Mr. Franklin, who was a public defender in this courtroom, had your case for a bit. He got moved to another courtroom, and Ms. Patel was taken over Mr. Franklin's cases. She's now your lawyer, and she is here to argue bond on your behalf. That's all we're talking about. You still face these charges, and my goal is to get you a new trial date as soon as possible because, as mentioned, this is an indictment in 2014, so it was all long ago. Trial was back in 2015. To get closure, whatever closure might be for you and your family, and obviously for the family of the man, it sounds like was shot and killed that night. It sounds like it was shot and killed by you. The question was, who shot first? And so was it self-defense or not? Not did you have a gun, a revolver, and did you shoot this guy a few times? Did he shoot you? That's my limited understanding of where we are, having reviewed the record, all of which is publicly available. And Ms. Patel, I turn it over to you. Mr. Abate, I will hear from you at the appropriate time.
Yes, Judge.
Thank you, Your Honor. Today, my client is supported by his family members. His 5 children are present in court today, as well as their mother and her other children. His girlfriend is present in court today with her mother. My client's mother is present as well as his cousin, brother-in-law, and his sister. Your Honor, my client before trial had a $360,000 bond that was set. That bond, currently he is in no bond status. I believe that bond would be what dictates, now that we're sort of back to his pre-trial setting. And so we are asking for a reduction of the $360,000 bond. What we are asking for, Your Honor, is a $60,000 bond with a ankle monitor as well as a curfew in place for my client. My client has no felony history. I do not believe that he would have any risk to re-offend should he be placed on bond. His previous bond was not something that his family was able to make, even though they were able to retain a private attorney on the charge. I have spoken to them about what a reasonable bond for them would be. They are hopeful that they could afford a $60,000 bond. It's not a guarantee. He has a lot of ties to the community. He's a lifelong Atlanta resident, born and raised. His 5 kids are here, as well as his mother and sister. Were he to be released on bond, he would reside with his mother. She lives at 689 Dill Avenue, Atlanta, Georgia, 30310. I spoke to her and she indicated that this address is nowhere near the incident location, and that should Your Honor impose a stay away from that area, my client would have no issue with that as well. At that residence, her one daughter lives there, Tatiana. His mother works as a nursing home attendant. I do not believe that my client would be a threat to any witnesses should he be released. Interestingly enough, at his trial, several individuals testified. There were 3 individuals that were shot that my client was charged with. At trial, those 3 individuals did not testify to my client being the one that shot them. Benny Martin, who testified at the trial, was and may currently be incarcerated in Calhoun State. When my client was incarcerated, he had seen Benny Martin in the same prison. They never got into a fight. There's no bad blood between them. Cedric Jeffries, another witness, is currently incarcerated at the Fulton County Jail. There are no incidences between my client and Mr. Jeffries. There have been no reports from Mr. Jeffries that my client has in any way threatened or influenced him in any way. Shane Huggins also spent some overlapping time in Fulton County custody while my client has currently been in custody, as well as Sir Rafael Yaman. Ultimately, the most interaction that my client has had is by the nature of him being in custody, that he's interacted with these individuals, and there have been no incidences between them. If he were released in custody, I feel that he would have less of a chance to come across any of those individuals. I do not believe my client would be a flight risk. Physically, he cannot go anywhere. During this altercation, my client was shot 5 times. Part of his foot was amputated. Before the trial, he had underwent 10 different surgeries. Since he's been in prison, he's underwent 5 different surgeries. I obtained his medical records. Currently, his wound bandages need to be replaced every other day because of an excessive amount of draining that occurs.
These are bandages he has now for something that happened 7 years ago.
Correct.
Okay.
And so he's expected to continue to have more care down the road. He is on the highest dosage of blood thinners that he can be on because of severe clotting issues with his injuries. And so I believe that his medical condition, 1, places him at a greater risk while he's incarcerated, but 2, prevents him from having any meaningful sort of flight. I don't believe he, that would cause him more harm than good.
Why a curfew then as opposed to house arrest? It doesn't sound like Mr. Beard would be working, but maybe you were gonna get to that. But if he's not working, then it would seem like a scenario of you stay at 689 Dill, except for medical, or you can come up with a list of the must be able to go to, but it doesn't seem like Mr. Beard's in a position to go work in a warehouse or be a doctor, or whatever his background might be.
And that's correct, Your Honor. We do not oppose house arrest. I spoke to my client in depth about the fact that he's not going to be able to work physically, and he understands that. We would just ask for the exception for court dates and medical appointments. But given all of those factors and the fact that my client has been in custody since September 20th, 2014, without any of these witnesses indicating that any threats had been made to them or any jail or prison incidences arising between these individuals, I believe that he would be a good candidate out on bond and that he could avoid the areas as well as the witnesses and would abide by any sort of stayaways that Your Honor puts in place.
Okay. Thank you. Mr. Abate, state's position, and in particular, if you could focus in on what I was focusing in on, which is given Mr. Beard's medical condition, frailty, et cetera, why house arrest effectively is what it would be, isn't a reasonable situation given all of the factors I'm supposed to weigh. Does not include the jury found you guilty of shooting fatally one person and non-fatally two others.
Yes, Judge. Well, to address some of those issues, the first, I believe, or the state would submit to the court that the defendant is a risk of flight due to the very reason you just mentioned. He was convicted by a jury of 12 people of all charges except for 2, I believe, which were counts 4 and 7.
Relating to Mr. Jeffries, so it's the aggravated, it's the shooting of Mr. Jeffries and then supposedly hurting his finger, I guess, as a result.
Yes, Your Honor. The state would submit to the court that he was then sentenced to life with or plus 5 years based on those charges by Judge Downs. Because of that, Your Honor, the state would submit to the court that he is a risk of flight due to being convicted of the felony murder, which have a mandatory life sentence with a life without parole as the maximum, Your Honor. I would also submit to the court that the defendant is a risk of danger to the community and the people in it. The evidence from trial did show that the victim, Mr. Bilal, was shot 5 times in the back. The testimony from witnesses was that Mr. Bilal was turned around leaving the incident. There were several, or 2 or 3 witnesses, as Ms. Patel did mention, that had to be impeached. They close in time to the crime, from which they were interviewed by the detectives, gave that set of circumstances that had occurred. Obviously, once they came to trial and were faced with testifying in front of the defendant and the jurors, did have to be impeached, or their recollection needed to be refreshed as to their previous statements, Your Honor. I'd also submit to the court that though the defendant does not have any felony convictions, he does have several felony arrests in which 2 in 2005, he received PTI from the court. I believe it was Judge Bensonetta, Tipton Lane. Also, Your Honor, there was a case that was pending in front of Judge Downs, which was 15 SC 133981. It was a obstruction of officers. He was resisting, excuse me, arrest, and when he kicked one of the officers in the stomach, as well as damage to governmental property and criminal damage in the second degree for breaking a windshield of a female he had known. That case was dismissed, but it was dismissed after he was convicted of the charges that are before Your Honor today. And it was dismissed in the interest of judicial economy because he was serving a life +5 sentence, Your Honor. As it pertains to the risk of intimidating a witness or the further obstruction of the administration of justice, I would agree with Ms. Patel. I don't have any evidence. I haven't listened to any sort of jail calls or anything of that nature to determine if there has been any witness intimidation. I would bring to the court's attention, as the court is aware, Mr. Beard did sit through the entire trial, and he understands the testimony that the witnesses have given and would likely give again at the trial before him, which makes him a risk of intimidating witnesses, Your Honor. But I have absolutely no evidence of that. As it pertains to his medical issues, he's been in custody for quite some time, and they have been adequately addressed here in Fulton County as well as in the prison system. So I don't believe that is an appropriate basis for his release at this time, Your Honor. And we respectfully request you deny defense counsel's motion for bond.
Do you, Mr. Abate, have any input from any of the victims or the family of the deceased?
Yes, they vehemently request that the bond be denied. I don't have any evidence that Mr. Beard has reached out to threaten any of them. There are family members, specifically Mr. Solomon's girlfriend, who was present at the time of the shooting and did witness it and did testify during the trial of the case. And she fears Mr. Beard because of all of that.
Okay. And I don't know how much time you spent with the file, but if we were to try to fast track Mr. Beard's case to get him back in front of a jury again, what kind of timeline would make sense for the state? I'm assuming there's not new discovery, other than if people are interviewed and there are recorded statements of those would need to be disclosed. But
so there is no new discovery, and I believe all discovery has been produced at least once.
We've received the paper discovery, but we were never given the digital discovery because we weren't on the case initially. We don't have that.
I'll do that
Okay.
right now.
And I'm gonna ask you the same questions, don't worry, but I wanted to know from the state's perspective, if this is something that could be ready in a week or a month or 6 months, because obviously the more time you say you need, the more that weighs in favor of, well, why should Mr. Beard be waiting for the state to get ready? But there's a balance to be struck.
Your Honor, I believe 60 days would be appropriate given the age of the case. But I think in 60 days, the state could be ready to move forward again with Mr. Beard's trial.
Okay. Ms. Patel, same two sets of questions. One, was there any input that Mr. Beard's family wanted to provide other than their impressive presence? A lot of folks here for Mr. Beard, and that is not typical, and is a sign that there's a support network for Mr. Beard, which is a good thing. But was there anything specific or
Yes, Your Honor, Yolanda Beard, my client's mother, I would like to address the court regarding comments.
okay? The way we need to do this, Ms. Beard, so that the court reporter can hear you, she is not in the courtroom, is you need to come up to the podium and talk into that microphone, please. Good morning.
Good morning.
What do you want to tell me?
All the phone calls that I get from my son, we always have a talk about the Bible. I know my son changed. I know he have. Because everything that we talk about, it inspires me. Because I'm about to break down.
That's okay. This is a complicated topic, so you take your time.
I pray every day that I see my son. He's good. He's a good child. I know he's a good child. And I just pray today that a bond will be granted for him. We always talk about my grandkids. I have a lot of grandkids. They beautiful grandkids. He always talk about how much he want to be out here with his kids. Because, you know, kids nowadays, they tend to rebel. And I just want him to have that chance to inspire his kids of what he went through, you know, to let them know these things are not right. And they love their dad. They talk about him all the time. And I'm just asking, by the grace of God, that he be granted a bond.
Okay. Ms. Beard, Mr. Beard would be living with you if he
Yes.
got the bond
Yes,
at 689 Dill.
yes,
Is that a house or an apartment?
it's a house.
It's a house. Do you own that house?
No,
It's a rental.
yes.
Okay. And who lives in that house right now besides you?
Me and my daughter Tatiana, she's back. She's here.
Okay. And anyone else? Do you have any of your grandkids stay with you, or does Tatiana have, I guess those would be your grandkids. Do any of your grandkids live with you, or it's just you and Tatiana?
Well, one of my grandbabies, she's there just limited time.
Okay. But the main occupants would be you and your daughter.
Yes,
And then your son would have his own room there?
yes.
Okay. Okay. How long have you lived at that address?
About 12 years.
So it's a stable
Yes.
residence for you?
Yes,
All right. And I think Ms. Patel said you do nursing work?
yes. I've been on my job 17 years.
Okay. And your daughter Tatiana, does she work?
She's school. She goes to school. She's going to school for dentists.
Got it. Okay. Thank you. So Ms. Patel, it sounds like you've got paper discovery. You can read the trial transcript, et cetera. We've all got that. But you don't have, I guess it would be recordings of statements that people gave to law enforcement, some of the impeachment materials that Mr. Abate was referring to.
Yes, Your Honor, essentially, any of the digital discovery that would have been provided to the previous defense counsel.
Mhm.
And then, perfect,
Oh,
thank you.
sounds like it just arrived.
And then and I'll speak with Mr. Body about this. The copies, some of the copies of what I have are copies of copies of copies. So some of the material is not easily readable, but it's nothing that should hinder us from moving forward on those documents.
Okay, well, the record should reflect that Mr. Abate just handed you a thumb drive. Mr. Abate, is it your understanding that that is the universe of digital discovery, or you're hopeful that it is?
That is all. That is all the digital discovery.
Okay, so Ms. Patel, you should have received, I know you haven't looked at it yet, the discovery in this case. I'd ask you sooner rather than later to look through it to make sure there are no corrupted files or things that are hard to read, assuming that that thumb drive has everything the state has, so disclosure is complete as of today. How much time would you want to be in a position to say, ready for trial for your client?
I would say realistically, at least 90 days.
Okay. So I had a trial, assuming we have jurors and whatnot in March, a trial week of March 7th that I was eyeing. That would be consistent with the 60 days. It would not be consistent with the 90 days. And so you would be asking Ms. Patel that we not set Mr. Beard's case down for that week of March 7th, but that it be in April at the earliest.
Correct.
Okay. Okay. We don't have our jury selection dates yet for April, May, or June, but we're working on that. This will be a reason to expedite that. All right, Ms. Patel, anything else you wanted to add in response to what you heard from Mr. Abate?
No, Your Honor.
So, Mr. Beard, your situation is a complicated one. Ms. Patel has pointed to a number of reasons why bond might make sense if we were sort of in a vacuum of there are these allegations against you, because that's where we stand. Right now, you have the presumption of innocence back because of Judge Downs's order. But it is difficult for me to, I don't think I'm required to, ignore the fact that after hearing all the evidence, 12 folks unanimously decided that you actually did the things, minus 2 of them, that are charged in the indictment. So it's not the same scenario as if we were having this conversation, let's say 2 weeks after you turned yourself in or were arrested. I don't know how you first went into custody, but whatever that situation was, you got locked up at some point. Sounds like it was in September of 2014 in connection with these charges. And a discussion about bond then, everything that Ms. Patel had to say would be in some ways more compelling. Some of them wouldn't apply. You had not been shot at that point. So you were younger, you didn't have the medical issues that you're working through now. But I am wrestling a little bit with how to balance the different factors that I'm supposed to balance. I am encouraged by the fact that the state doesn't see any reason why it could not be ready soon. And Ms. Patel, I know, will work hard to get ready on your case, but she wants to be realistic so that she's fully prepared and not half prepared to represent you should this be a trial. Again, there's always the possibility that you decide to work something out. And who knows what the state might offer after they review the file and they have to find all the witnesses again. That's not your project, that's their project. So things could change on that front. What I'm going to do for now is enter an order for a bond. It is not going to be as low a dollar amount as Ms. Patel asked for, but what I am going to do is invite Ms. Patel to renew her motion for bond if, when this case appears on a trial calendar, which will be in early April, if the state is not ready, then for whatever reason, then I'm going to invite Ms. Patel to renew the motion for bond, and we will talk about a dollar amount that is one that your collective family, all of whom are here to support you, might more realistically be able to meet. That's not to say that they couldn't meet the amount that I'm going to set in a minute. But I heard Ms. Patel pretty clearly that the $360,000 bond was the same as $1 billion bond. It's just an amount that you weren't going to be able to post. I'm going to set something a little lower than that because I ought to really just say no bond if I'm going to say $360,000. But given everything that I've heard from the two sides and my review of the file, what's in the docket for this case, I'm not comfortable setting a bond at $60,000 given the nature of the charges and what has already happened in this case. So we still have in the indictment 6 of the 8 counts. 2 of them won't be tried again because you were found not guilty. So let me get back to the indictment. So what I'm going to do is set a bond that's a total of $150,000. It's $100,000 for count 1, and then $10,000 for each of the other counts that still remain, which are 2, 3, 5, 6, and 8. That will be through the sheriff's 10% program, which means, Mr. Beard, if your family is able to post 10% of that amount, they'll get it back when your case is finally resolved. So it's not just money in a bonding company's pocket that your family doesn't get back when the case is closed, however it's closed, but it will go into an account where it is held and it will be returned when the case is resolved. Should you post bond, you'll be required to wear an ankle monitor, and that ankle monitor will need to be on before you are released. And you will be required to live at 689 Dill Avenue with your mother. You'll be subject to pretrial supervision. You will be on house arrest, meaning you may not leave that address except for medical appointments, for which you'll need to get clearance from pretrial services. In other words, here's proof that I'm going to go see the doctor for X or Y or Z, or obviously a medical emergency. If an ambulance shows up at 689 Dill to pick you up, you need to deal with that. You also can leave 689 Dill to come to court if you've got any court proceedings. I'm going to limit it to those 2 things initially. If it turns out that there are other reasons that you think are compelling as to why you need to leave the house, you should let Ms. Patel know, and she can always file a motion to modify the bond and just make something up. It may be that you have to go to physical therapy. Well, you should go to physical therapy if they're not coming to you, and we'll modify it. That would be part of the leaving for medical reasons, if it's not clear enough for pretrial services. And importantly, it would be a condition of your bond that you have no contact, direct or indirect, with anyone who was named as a victim in your indictment or who testified as a witness at the trial. That means obviously you don't contact them, but no one from your family or circle of friends reaches out to them either for any reason to say, hey, just want to let you know I'm out. That would be contact. That would be inappropriate, or to try to influence them in any way. The one person who can is your lawyer. Your lawyer is free to reach out to anyone and obviously would be doing that on your behalf. But if it's not your lawyer or her investigator, then I should not be hearing from the DA's office, hey, John Smith is getting weird texts from someone about Mr. Beard's trial. If we figure out that those texts came from someone associated with you, that is the quickest way, short of getting arrested, to have your bond revoked. Mr. Abate, any other conditions that you would want to see on Mr. Beard's bond? Ms. Patel, I didn't mean to switch it up other than a dollar amount. Did I impose any conditions that were inconsistent with what you described that you think would make this more problematic for Mr. Beard?
No, Your Honor.
Okay. And as I said, we'll figure out once we know what our jury selection days are in April and May, a date for this case. I think especially setting it may help because the state may need to be pulling people out of custody to testify. If that date comes and the state asks for more time and I give them more time, I'm relying on you to say, well, wait a minute, we had this discussion. It's time for Mr. Beard's bond to be put even more in his reach than maybe $150,000 is, which is more than a 50% reduction than what Judge Downs felt was appropriate before the trial.
Is this a joke?
Anything else, Ms. Patel?
No, Your Honor.
Mr. Abate? Okay. Thank you. Hold on one second. Before you go anywhere, I just saw a chat. It looks like we had, take a seat, please. Members of Mr. Belai's family joined the Zoom call. So I thought we had a victim advocate on who was sort of mediating this, but there were some, she seems to have dropped off. So if you are on the call, I have a couple iPhones and it doesn't say who the iPhones belong to, but if you are part of the Belai family and would like to be heard, I would like to hear from you. I did not know there was someone on the call from Mr. Belai's family.
Hi, I'm Solomon Belai's baby mom. His only son is 15 years old this year, and he's a straight A student, and he's going through like a whole lot of depression that his father is not here. The sad thing is about it is Dexter and Solomon was friends. Dexter was my friend, you know, and the fact that he killed my baby father brutally, you know, with his back turned, and we're never gonna see him again. It just hurts. And we just pray that justice be served for our family, and that my son, my 15-year-old son, justice be served for him as well, because it's not right. It's not right. My son, Dexter had 5 kids. Solomon has 1, and Solomon is never gonna be here ever to see his son graduate, to see his son get married, to see his son from high school. None of that. They took that away from him. And so now I have to raise my son by myself, you know, and it's hard out here to raise a young man in this world by yourself, you know, accurately, to be the man that he's supposed to be without a father, you know. So I just pray that the courts take all that into hand, that he do have people out here, Solomon Belai does have people out here that loves him and support him, and we're here for him. And
Good.
my son, he's here too. Solo, come here. Come here, please. My son, he's here too, and he wants to speak on his father's behalf, if that's okay.
No, that's fine. And I appreciate you speaking up, ma'am. And I'm real proud of what you've done with your son. A straight A student at that age is real impressive.
So say something on your dad's behalf.
This is ridiculous.
Excuse me, I need names for the record, please.
Sure, ma'am. Could you say your name again, and then we'll have your son introduce himself.
I'm Elvon Crawford.
And I'm Solomon Abate Belai
Jr.
This is ridiculous.
Okay, tell me what's ridiculous.
All those years we did, everything he did, my dad was hurt when he killed him. I have to live all these years depressed and sad, hurt over this.
That you'll never see him.
I've been crying every night. Every night. I had to watch him bury my own father. I have to look around everybody else, no father, no nothing. And I'll have to be okay with that. And now he about to walk free? What? He has his own family. That ain't fair for me.
Okay, baby. And we just want to have justice. That's all. We just pray for justice, and we ask for no bond because it's a murder case. I don't think that we understand that Dexter's hurt. He has wounds, but Solomon is deceased. He's never coming back. Solomon would never speak to his son. He'll never see his son again. And that's just the hurting part of the situation.
Okay. I appreciate that. I appreciate you sharing that, and I wish you the best with your son. It's clear that he, after all these years, is still wrestling with this, and it is a big contrast to what we heard from Ms. Beard, who wants her son to be with his kids, and you're pointing out that the father of your child's not able to do that at all. He's gone, and that's a
Not even
big
a phone
difference.
call. We can't even get a phone call, just say, hey, how you doing? It's grateful that it's a blessing that his kids get that, but we don't.
Right. Okay. Well, thank you. I know there are a couple other family members on. Who else is there?
I am the sister, the only sister. And you took everything away from us. My mama came here with nothing. And to hear your mom sit there and speak to you like that, that's foul. That's not fair. You hear what my nephew's dealing with. My brother, the mother of his child, me. I was pregnant when you took my brother away. I was pregnant with my first child. You didn't even give me the chance to let him know I was having a child. And y'all want us to sit here and feel bad for you. I don't feel bad for you. And whatever happens, happens. I don't have nothing else to say. I'm done with this.
Okay. Anyone else?
I'm here. I have something to say.
Okay. And you are?
I'm Jamila. I'm Solomon's cousin,
What's your last name, ma'am?
Muhammad.
Okay. And what do you have to say?
I am very hurt. He took a really good person away. There's no reason that he should see the outside of that jail prison. I'm sorry. That's all I have to say.
You don't need to apologize. I am sorry that we didn't recognize you all. I didn't see from the list of participants. I don't think Mr. Abate knew that you all had dialed in. He usually has someone helping him.
We've been here since the beginning.
Okay, I'm not doubting you at all. Usually there's a victim advocate who connects you to Mr. Abate so that he knows there are some family members of Mr. Belai who want to be heard. So I did not mean to pass over you, and I apologize if you felt that there was any effort to not hear your voice in this process. It's an important voice. You have a right to be heard. You have a right to notice. Clearly you got notice because you guys dialed in, but I will be more watchful the next time we have any proceedings in connection with Mr. Beard's case. And I didn't, by anything I said or did, mean to suggest that your input was unimportant. I know that Mr. Belai left behind a number of people who loved him dearly and cared about him. And I understand your frustration with the way this has unfolded. All right, Mr. Abate, anything else now that we've heard from some of the friends and family members of Mr. Belai? All right, Ms. Patel?
No, Your Honor.
Okay. Well, I think we've heard another reason why it's very important that Mr. Beard continue to have no contact with anyone associated with any of the victims in the case or any of the witnesses. And there's overlap there because there were a couple of people who were shot who did not die. They would be both victims and witnesses. Ms. Patel, I'm going to rely on you to let me know if there is any hang up with discovery, but I saw Mr. Abate hand you the thumb drive. So I'm going to assume discovery is good. If it's not, let's jump on it sooner rather than later so that we don't extend the somewhat aggressive timeline we're agreeing to have a case from 2014 trial ready in just a few months. All right. Thank you, everyone.
Yep, will do.
All right. Yes, sir. Thank you. Yes, sir. Happy New Year.
See you on the sixth.
Yep. So let's talk about Mr. McLean. Ms. Wood, do you have an update on position 3, Mr. McLean?
Yes, Judge, I think we're probably going to end up needing a little bit more time on this one. I did speak with ADA Charles. I also spoke with Officer Woodward, and I think we're probably going to need to waive arraignment today and just move forward to a new court date.
Okay. Do you need Mr. McLean to come out for any conversation, or are we good?
Judge, if we could just bring him to the door. I had told him actually that I wasn't going to be here today, so he probably wasn't expecting anything to happen, but he does have a probation matter that I have been speaking to probation about and Ms. Charles. And so I think it's probably in his best interest to waive arraignment today.
Okay. Can we bring Mr. McLean to the door, please?
Thank you, Judge.
Yeah, and I'm sorry to interrupt. I just wanted to know if ADA Charles was still in the courtroom because I haven't gotten a call yet. Or at least if I did, I had stepped away and I didn't get the phone.
Okay. Oh, I thought you were going to do that during this long bond hearing because that didn't have anything to do with you. Oh, okay. You don't need to worry about it in the future. If there is someone from your office at this table, you're free to step outside for whatever reason. So I'll be clearer next time, but I thought we had Mr. Abate in here running the show for the DA's office. And so you were able to reach out to Ms. Bernard. So Ms. Bernard, don't give up yet. There'll be a chance. Let me just knock out 2 more from this. Ms. Patel, what's happening with Harvey Johnson?
Your Honor, Ms. Charles needed to reach out to the complaining witnesses about restitution before we could try to move forward.
Okay, all right.
Was it McLean?
McLean, yeah, James McLean. Not here. Okay, so you're going to waive arraignment on his behalf and we'll move that forward.
Thank you, Judge.
Okay.
Alternatively, Your Honor, if we cannot resolve, I'll be asking to address his bond today.
Okay, well, I'll give you guys, I think all that's left now is Ms. Baldwin, and I'm going to have Ms. Charles call Ms. Bernard in just a moment. So we've got Ms. Baldwin and Mr. Johnson. I think that's it because Ruddick didn't show up, but we're going to work through whether he needed to show up. So I'm going to take a quick break. When I come back, let's figure out what we're going to do, if anything, with Johnson and Baldwin. Okay, so if you'd start, please, Ms. Charles, by calling Ms. Bernard. And you can do it right there if you want, because we're going to take a little break.
Judge, may I be excused?
Yes, ma'am. Thank you for joining us.
Thank you. Have a good day.
You too.
Are any of you these individuals on their Gmail list of numbers?
Oh, no, I'm sharing. I think they could make it to.
Okay. So I don't have this file. So I explained it to her, but I don't even know. So I told her that, one, I'm waiting on the pilot, and two, the state needs to serve me which is to predict all the evidence in their case. And so once I receive that, the file motion, because we'll be getting one in bond, and so I explained to him that I wait until I get everything to the bond. Strengths and weaknesses of the so he so his that and like I said, I'm very familiar with it because I don't know anything about it other than challenge. So there are multiple court cases that happen based on what I filed. So let's see. Charles being statement. And if it was not a good statement, then I would file some real something the state files things that they want to introduce evidence at trial. And so we have to a monitoring would be something that we plan to have at some point. All of those get scheduled. We don't get all of them because they wait to file the motions to schedule. So what I explained to you is that the state will be given a deadline, which they have to get all stuff. And then I'm given a deadline in which I file all my motions, so our motion, whatever. And then that's when it triggers. Some of that stuff. His in having someone keep coming in without any movement on the case. Usually that's something that actually happened or that movement. And so people told me his mother and father passed away, right? He had a sister. What's her name? Okay, so this is his sister. He didn't know. And your name was and you're a family friend? Yes. I know, that's in March, you said 2020. And what's your phone number? And because I need to reach you some people. The other thing that was and I don't know, I don't even know what the initial location, but who they're saying is below or not. But I know that Mr. O'Neill is and he's not so that is another when it possibly affect the same because they're on and just how that I that file and review everything and all speak to them about everything and the strength or weaknesses. Okay, I'll give you my card in case you have any questions that come up. I don't have any court dates that I know of yet, but I can always reach out or you can call me if you need court dates and I can get, or email me and that's a quick, nothing coming up yet. Usually you saw the other ones where if I have a lot. Friends that they can be present. Right. Discuss it.
So you.
Okay.
That's what we. Gotcha. Thank you so much.
Of course, and I appreciate you guys paying for that. Oh, we do.
Okay.
Thank you. Take care.
All right, you too. Yeah. Thank you. Just because it is. It's really sure. Publish it.
For Brochet,
Because she. That, well, whatever she hit down. And then the town is here for the.
I'm here if anybody needs me, and after I talk to Miss Charles, I will need to talk to her, Miss Brochet, to let her know what the offer is. Just FYI, this Miss Bernard, thank you.
Okay. Right. Yeah, yeah. Okay, and then whenever you get a chance on Harvey Johnson. Yeah, well, I mean, the family members are, so, yeah. But but in terms of a resolution, if you can get in touch with.
My issue.
Right, yeah, so let me know if you're able to present.
Because if we can do that.
Right, okay,
It's just. That he did damage.
right.
But I need to get this.
Right.
Is Judge coming back to the bench?
He said he's gonna take a few minutes, so he's giving you time, I think it's just whether, like, when you're ready, you can.
It's just different. It's different.
Yeah, I'll be here, I'm gonna just speak to my.
Come on.
Right here. Okay. So it was 15 minutes. And you have to be. So you guys are just. I have to. Yeah.
So that's what
Ah,
everything has,
beautiful. Thank you.
I got all original. I did not re-include
The other
the
stuff.
stuff I gave you just.
Okay, cool.
And then this jump drive is weird, because we have new drives that require passwords,
Oh, God.
so I put it right here. It's
Okay,
made it easy.
cool. It's all like a victim impact statement. It's really what it all is.
Oh. She went down there. It's the earliest problem. She didn't really know.
This is traumatic for me so much because you're really showing us.
And you're telling me this.
Yeah, yeah. We don't have anything on this upcoming calendar, right? Because you're not doing Shari Grant.
No.
Okay.
And then I just got signed Glenn Goolsby.
Oh, yeah, Marilyn is only gonna be ready on one of those, because she's on Goolsby, she's doing Goolsby, Hodges, and Lowe.
Well, Lowe's not gonna go. They just signed an order for him to be evaluated.
Okay.
So I guess we don't know when we'll get rescheduled. I think it's just.
Mhm.
Now, to like work on getting the discovery for children.
Hello,
Hello.
you're back.
I was given a.
Yes, so-
Digital copy of all the discovery for it.
There's more Beard.
Well, she has it, it's been in paper form, it was already digitized, so I just put it on a drive for her as well.
Great.
Do we know when, we're gonna resume?
Good question. I think, well, you were on, you may have been able to hear what I was describing to folks who were in here. The only pause is in-person jury selection. And that is through the 14th. But it will be revisited Wednesday of next week. All forecasts are that it would be extended until we see a decline, because there seems to still be an increase in numbers. So if I were a betting person, I would bet that the hold on in-person jury selection runs through the end of the month. We'll work as a group on this. We're gonna have our group session on the 6th, whenever it is, to say, what does the trial calendar really look like? I didn't bring it out with me. I don't remember our first jury selection date, but
It's right.
it's what?
It's the 12th of January.
Okay, so that won't be happening.
Right.
That won't be happening, and we don't get a bonus one as a result. We just don't get that one. So that will affect the discussion that we have on the 6th about what those other weeks will look like and what we can fit in them. If we have another January one, I don't remember if we have another January one, we'll tentatively plan that we're going to do that, but it may fall apart because we're not going to be picking juries, and then we'll just sort of rejuggle things. What you all should be thinking about is there something that is a must try for whatever reason? And then do you want to have it sort of somewhat specially set for one of those February or March? We've got a bunch of dates to work with, and some of them are far enough out that I feel pretty confident that we'll be back in business. You know, they're the competing pressures of let's be safe, and how many more years are these guys going to sit at Rice Street before they have a trial? That's no one's fault. It's just that they're stuck. If you all have cases that look, could this please be number one this further week out? Let's have that be part of the discussion. Because usually you say, yeah, I could be ready that week. And then I decide, well, I'll have this one be number one and this one be number two. And sometimes I'll put something ahead of what you all say must be tried, only because I got a pretty good feeling that'll make that case go away.
Right.
But be ready to signal to me on the 6th. This is one that we'd really like to try, because my client's he wants his trial date. And you're having to prioritize, you and Ms. Wood internally, let's have this one go ahead of that one. And obviously you can only do one trial at a time. And so your prioritization is helpful as well. And if you're neutral, you can just say, look, we can be ready on these cases on these different weeks. And then Ms. Nelson and I will think about how we want to prioritize.
Do you think Mr. Lowe will be one of the first ones to go, Daryl Lowe?
So that's a good question. I was what I wanted to have go on the 12th or the 14th. I mean, the goal was to, the weirdness, let me be looking at a calendar while we talk about this. We do two things.
That's Ms. Lowe, you know, she's like Houdini. She figures a way to
Try and get real fast.
Give me 1 second. speaker. Let me unmute. Now she should be able to hear you.
Miss Bernard, are you still on the call?
I am.
Miss Charles indicated that she is going to try to get, she reached the complaining witness in Miss Baldwin's case about restitution. That she's going to try to get to you, so that you can then speak with Miss Baldwin about their global offer.
All right, thank you.
Yep.
So with Johnson, Ms. Charles needs to still talk with someone. She's been focused on Baldwin. With Baldwin, if she gets information, ultimately, we're going to need to figure out how to get Ms. Baldwin and Ms. Bernard connected.
Correct. That might be well, I guess they don't have the restitution number yet, but.
Is Ms. Baldwin mobile? And if she can come out here, we could get her in and they could speak on Zoom if the rest of us stepped out. Okay.
That'll work. Thank you.
Great. Thanks for sticking with us.
You're welcome. Thank you for working with us.
And Your Honor, may I approach with the waiver of arraignments?
Yes, ma'am. Thank you for filling them out for Ms. Wood as well. Did you have a good holiday break?
Well, I had COVID, which really ruined pretty much everything.
Oh, bad symptoms or just you tested positive, so you had to do what you have to do?
I was pretty sick for a week of not leaving the bed.
Yeah.
I don't think I had Omicron because I lost my taste and smell too.
Mhm.
Up until like yesterday, I got it all back. But I mean, you know, I watched a lot of TV, which was nice.
Caught up on all the series?
Yeah.
That's funny. Were you planning on going somewhere?
Yeah, so I was supposed to go to Houston to visit my boyfriend's family, and that just didn't happen, which I think, I mean, I'm glad I knew before I got on a plane.
Did he still go to be with his family or?
He didn't. We didn't want to risk he had tested negative the entire time, but it just seemed risky to do
Yeah.
that. And his, all his relatives are over 80.
Okay, so it's smart not to risk it.
Yeah.
Mr. Sargosa, are there going to be evaluation issues with him, or that's not why you were with him so long?
We thought that there might be, and it's still very difficult for me to tell
Okay.
because of the interpreter.
Sure. It's in that space, but it wasn't so clear that you're saying time out, let's get in, but there may be a way to sort this out.
Yeah,
Okay.
he had very clear requests, and I do feel that he's not wrong that this should resolve given the length of time he's been in custody. It just isn't going to happen today.
Should I change, you filled it out for Mr. Sargosa and you say the defendant does not require an interpreter. Doesn't he require?
Oh, he does. I
Okay.
apologize.
Someone is unhappy. What forms would be most helpful to you to have available online? Or do you just carry around a packet of all our forms? Because we're going to be updating these so they say 2022, all that kind of stuff. And I was talking with Ms. Nelson, well, we should just have them, like you can see the standing orders on the website. You know, we're revising the court's website. It's time to add things, and commonly used forms we ought to have available electronically. Less so for you, Ms. Wood, because you're here all the time, but still, you may be plugging in remotely, but we get these attorneys like, oh, how do I waive arraignment?
Right.
Oh, we have to email you the form, but if there was a PDF of it on the website, that would be helpful.
Yes. I know that the private attorneys also struggle with the accountability court forms.
Mhm.
They don't have much familiarity with those if those were readily available. And then the plea colloquies that are, I believe Your Honor has a new one that's in Spanish that we used recently that were online.
Okay. So the plea sheet, waiver, and then some of those accountability court things.
And then it seems like these might be more relevant now, the waiver of presence
Mhm.
at hearings as
Yep.
well.
Everything all right?
Yeah.
Is that one of our folks or Lethbridge?
We got two. So we got people from
Lethbridge?
Mhm.
Okay, someone was unhappy.
Yeah. Everybody else done?
Hey, Ms. Charles. How are you?
I am getting there.
You're getting there. Who knew you were going to have to be jumping on all this?
Right, I got my running shoes on today.
So tell me where we are with what Ms. Patel told me was that you were first working on Ms. Baldwin.
Yes, so we were able to contact the service manager for the Imperial Hotel. The biggest issue we wanted to confirm was the amount of restitution. Initial numbers we received said something between 2,000 and 25.
That's a big range.
That's a big range. However, the service manager said he received an actual invoice and it was actually closer to 30. And so he was going to email it to me. Now he gave me his cell phone number to follow up. It hasn't popped up yet. As far as that goes, but I have spoken to Ms. Bernard and communicated an offer that would probation with restitution.
Sure.
And so we're just waiting for that number unless your Honor was inclined to do to determine a number. I'm not sure if Bernard was mentioning something of that nature.
Sure.
But we wanted to confirm the number.
Well, why don't we, great, that's fantastic. And we'll continue to give this gentleman time to get you the number. Worst case scenario, assuming we need to get Ms. Bernard to speak with Ms. Baldwin, we're going to arrange that in a minute. But assuming Ms. Baldwin wants to go forward, knowing that it's 2,000 to 3,000 is the restitution range and not 20,000, then it may be that we go forward with a TBD. Once you get the documentation, I would amend the sentencing order to say it's this much restitution. But I need to get Ms. Bernard and Ms. Baldwin talking about that. So that gets us to number 2 for you, which is Mr. Johnson.
I haven't had as much luck with Johnson as I did Baldwin because we also have a restitution outstanding on that one. Because of the burglary charges.
Yep.
And there was some damage done, and we couldn't get in touch with the victim. So it looks like we may have to get a victim locate.
Okay.
So the numbers we've had, they just sort of lost now, and one of the other just rings out.
Why don't we do this then? I think you said you wanted to talk about bond. Are you in a position to talk about bond with Mr. Johnson's?
I discussed it with my so I guess that we want the reduction of this.
Okay, well, we'll get something on the record. Why don't we do Mr. Johnson and then we'll get Ms. Baldwin out here in court so she can talk to Ms. Bernard. I'll ask you to go to the jury room so that Ms. Baldwin and Ms. Bernard can speak. I'll leave as well and they can have their conversation. And if Ms. Baldwin is aligned with what you and Ms. Bernard have been talking about, you can give the hotel manager, hey, this is your last chance to get it in for today, but all is not lost. I'll just, if there is an agreement on the record that I am authorized to amend the final disposition upon adequate documentation of the loss to the hotel, we'll go forward. All right. So let me make sure the rest of the team is still around. Get the video back on. Ms. Rivers, you good to go?
Yes, I'm good to go, but I just like to say it is very hard to understand Ms. Charles.
Okay, well, we will get her closer to the microphone. And it may be that her microphone is muted. So we'll unmute it and get her closer to it. She was sharing it with Mr. Abate earlier, but thank you for flagging that.
Okay.
And then, Ms. Bernard, what we'll do when we're done with this brief discussion about bond for Mr. Johnson, we can bring Mr. Johnson out with that. Great. Then we'll get Ms. Baldwin out here so you can have a discussion with her. Does that work for you?
It does, Judge. I also would like to make the court aware, I have court at 1 o'clock. There are 2 cases on that calendar. I have to supervise the person, the attorney who's doing it. They're practicing under the Third Year Act.
Okay.
Then I also have a prelim at 2 o'clock.
Okay. Well, we'll use as much of your time as we can before 1, and then if we need to reconvene after you're done with those 2 other things, that would be great.
Okay, that'll work. Thank you.
All right. Thanks. All right, let's go on the record in 21 SC 179818. It's State versus Harvey Johnson. Mr. Johnson, I'm Judge McBurney. How are you?
I'm doing okay.
Good. I need you to be a little closer to the microphone so that the court reporter can hear you. Mr. Johnson, we were seeing if your case could be resolved today, but there are a few pieces that are missing. The prosecutor, Ms. Charles, was working real hard to try to get some restitution information. There's a claim that there was some damage done at a situation, and we're not going to talk about the facts of your case right now. But I think Ms. Charles is going to need a little more time to try to track those numbers down. So since we're not going to resolve your case today, your lawyer, Ms. Patel, asked that we talk about bond in your case. So Ms. Patel, if you would please get me oriented to what the concern is. I'm looking at a bond order that Judge Oliver entered on October 21 that has a $2,500 good bond for count 1, the burglary, and then essentially a signature bond for count 2, the possession of tools count.
Yes, Your Honor, that is just not a bond that my client can make. I've spoken to his family. My client lives with his grandmother and grandfather, who are both very sick, and they're cared for by a cousin that my client also lives with. Because of the situation that they're in with dealing with the grandparents, money is very tight for them. If my client were to be released, he could live with them. I spoke to the cousin to confirm everything. Right now, they've set up a sort of quarantine house to keep the parents away from Antonius, the cousin, as well as my client. Your Honor, I'm not sure if a burglary is a bond that my client could receive a signature bond through pretrial services, but that is what we would be asking for. He has only 1 felony arrest for shoplifting that was done under first offender. And then he has this case. He was prepared to resolve this case, not to get too much into the facts, but essentially he was found leaving a sort of a warehouse space. And he does admit entering into that space. He just disagrees with the reason why. While he was incarcerated, he was diagnosed with IBS as well as gastroesophageal disease. He has no control over when he needs to use a bathroom. And in this situation, he was walking back from work, which is a 6-mile walk. he thought about using the restroom on the walk, worried about getting an indecent exposure charge, thought that this was an abandoned building, that it wouldn't be a big deal if he entered. He did, couldn't find a bathroom on his way out, ran into the police officer. He also is HIV positive, and so he is dealing with a number of issues while in custody. He has one vaccine, is waiting to get the second one. With that being said, his family would gladly welcome them back. They communicate with him fairly regularly. I asked the cousin, you know, what could you make? And they said maybe $100. They just, $250 was too big of an ask for the family right now.
Okay. Where were you working, Mr. Johnson? I heard about a 6-mile walk from home.
I work at United Parcel Services. I got hired on the 6th of October. I have been working from the 6th of October all the way up to the 21st of October. The car that me and my cousin would share is down. So I would have to catch the bus to work, but walk home from work if I didn't have bus fare. And I work every day.
So you're able to work?
Yes, I am.
Got it. Despite all the medical complications you have,
sir.
You're able to work.
I'm able to work.
Okay.
But it's just, I didn't know that I had these issues as far as gastroesophageal reflux disease and IBS until I got incarcerated.
Okay.
Once I got into intake, I collapsed and had 3 seizures and had a massive bowel movement on myself because I didn't use the restroom, you know, where I was on the street before when I came out of the building that I went in.
Yep.
It was no bathroom. So I got lethargic, collapsed in intake. And that's when the doctor told me after I came to and they cleaned me up, they told me what I had. And I was told I have to have emergency surgery. If I get released, I have to go to Grady, see a gastrologist, and have a surgery so my intestines won't rupture.
Okay. We don't want that happening. Ms. Charles, it sounds like you're in a position to work the case out, but there's a restitution component.
That is correct, Your Honor. And so as a result, because we have not been able to make contact with the victim to confirm the victim's wishes and to confirm the restitution amount, the state is persuaded by Mr. Johnson's prior history or lack thereof as far as any violent crime. We are not opposing a reasonable bond based on Your Honor's discretion. We felt the initial bond that was entered was reasonable, but Mr. Johnson is still incarcerated. And so I guess that speaks to it. On the face of it, tells us that he's perhaps not in a position to make that amount. And so we would not oppose a reasonable amount in Your Honor's discretion.
Okay. So we have a known stable address. That's where the grandparents live.
Yes, sir.
And the cousin lives. I am not allowed under the law 17-612 to set a signature bond for burglary. Burglary is listed as a bail restricted offense under 17-612 A1B81. It's in there as burglary. So I have to set a dollar amount. What I'm going to do is reduce your bail on count 1 to $1,000. And I'll run that through the sheriff's 10% program, which means if folks who are supporting you, Mr. Johnson, can come up with $100, that gets you out. And they get most of that back when your case is resolved. So it's more of a loan. It's not bonding company takes it and you don't see it back. I'll leave the bond for count 2 as a unsecured judicial release bond, signature bond, but it will be $1,000 through the sheriff's 10% program, and you'll be subject to pretrial supervision My hope is I see you real soon, assuming you make bond, because we're resolving this case. You don't need these charges hanging over your head. It will be a condition of your bond that you reside at, what is that address?
It is 874 Deckner, Deckner Avenue, Atlanta, Georgia, 30310.
All right, so you'll need to live there with your grandparents. If you feel like you need to move, that has to be cleared through pretrial services, so they know your new address and that they're comfortable with it, that it's a safe place for you to be. You'll need to also stay away from this address on Donald Lee Hollowell. It's already in your bond, 2770 Donald Lee Hollowell. That's where this warehouse is located. If you get back to working at UPS, you walk by that place, just be on the other side of the street. Don't be caught in or around that structure while you're on bond. And I think that's it. Any other conditions of bond you'd want to see, Ms. Charles? It's a bond already granted. I'm just reducing the amount as to count one.
Yes, sir. No, Your Honor, no additional conditions.
Ms. Patel, anything else?
No, Your Honor.
Let's do this. If a little time passes and we aren't able to either resolve the case because Ms. Charles got a restitution amount, or Mr. Johnson hasn't made bond, let's confer again. We don't need to bring Mr. Johnson over for that. If you show me, look, it's been 2 weeks, we don't have a restitution amount, and Mr. Johnson's still in jail, I will entertain just a discussion with Ms. Charles and Ms. Patel. We can just do our own Zoom session as long as you waive Mr. Johnson's presence, and I'll consider lowering it again. I think Ms. Charles is right that this isn't a situation where we need to keep Mr. Johnson in much longer. We really need to resolve the case, and it sounds like he's poised to do that. We're just missing one fact. Okay, Mr. Johnson, any questions about what we talked about?
No, sir.
Okay, well, good luck, if that's the right phrase, with all the medical issues you're working through. Okay.
Thank you.
All right, Ms. Nelson, any questions about the bond?
No, sir.
Okay, thank you. So Mr. Johnson can go, and if we could bring Ms. Baldwin out next, please. And that should be it for who's back there that we haven't talked to. Ms. Patel, thank you for your assistance with the various folks you were pitching in on, who may have been Ms. Woods or even with Ms. Baldwin.
Happy to do it.
So Ms. Bernard, I'm going to have Ms. Baldwin come out now, and I will move other folks on the call into a breakout room. And Ms. Charles is going to go into the jury room. So you will have the courtroom as your private space with Ms. Baldwin. I'm going to come back out at 1 o'clock because I know you need to go, and I've got another hearing at 1, but hopefully during that window, it's about 20 minutes, you and Ms. Baldwin can make some progress if this is a case that's going to sort out.
Okay, thank you, Judge. A quick question. If it takes us less than 20 minutes to sort stuff out, how do I notify the court?
Send an email to Ms. Nelson, and she'll be getting emails, and she'll let me know, and I'll come right back out, and I can get Ms. Charles because she'll be sitting in the jury room.
All right, thank you.
You bet.
Yeah,
Yes, ma'am.
just want to remind you, they're still live on YouTube.
Yep, I'll turn all that off. Thank you.
Okay.
Is Mr. Connor back there? Is there a Mr. Connor here?
I don't believe we had a Mr. Connor.
Okay. Well, that'll make for an easier discussion at 1. All right.
I'm just going to hang out in the back of the jury room.
Great.
until then.
Okay. Ms. Baldwin, how are you? I'm Judge McBurney. He is here. Connor is here. Fantastic. Thank you. I'm going to connect you to your lawyer, Ms. Bernard, and you all are going to have a private conversation. I'm going to get everyone else off the Zoom session, so it's just you and Ms. Bernard to talk about your situation, because she has been working with the prosecutor who just left, so you can have a private conversation about trying to resolve your case today so we can get you heading where you need to head, okay?
All right.
All right.